Before I introduce our speaker, I have a few housekeeping reminders. Please stay muted throughout the program. Type your questions for our speaker in the chat room. I will gather them and address your questions with Professor Gilman at the conclusion of her presentation, and I thank you. We're pleased to have all of you on Zoom to hear Professor Michele Gilman present The Supreme Court Now, How It Affects You. Ms. Gilman is the Venable Professor of Law at the University of Baltimore School of Law, where she has taught since 1998. She directs the Civil Advocacy Clinic, in which her students represent individuals and community groups in a wide array of civil litigation and law reform projects. Professor Gilman also co-directs the Center on Applied Feminism that works to apply the insights of feminist legal theory to legal practice and policy. One of the center's main achievements was spearheading passage of a Maryland law that extended housing law protections to victims of domestic violence. Professor Gilman writes regularly about issues of feminist legal theory in both academic journals and popular press. You can find the links about her work on her webpage. She grew up in Columbia, Maryland, and attended Duke University and the University of Michigan School of Law. And we so welcome Professor Gilman.
Thank you so much for having me. I'm going to take 1 minute to just get my screen share up here so that you can see my slides. All right. Are you seeing my PowerPoint? Can I see some thumbs up? Okay, wonderful. So thank you so much for inviting me to join you to talk about the Supreme Court Now, how it affects you. When I was invited to give this talk, it was quite a different landscape at the Supreme Court because Ruth Bader Ginsburg was still alive at that time. And as I will discuss tonight, the landscape has shifted quite significantly. And we'll talk a bit about that. I think about and analyze these issues from a feminist perspective. I by no means expect that everyone in the audience tonight shares my ideological commitments, but I wanted to be, straightforward with you in how I look at these issues. So what I thought I would do is start with some background about the Supreme Court justices who are Jewish and are women and are Jewish women, and then talk about some of the recent case law and some of the issues imminently on the horizon. So, since the founding of our country, there have been 115 Supreme Court justices, 8 of whom who have been Jewish, and they are all pictured on this slide. We've had 5 women justices, and there is, of course, some overlap in those categories because 2 of our justices are both Jewish and women, Ruth Bader Ginsburg and Elena Kagan. Of our Jewish justices in chronological order, they're Louis Brandeis, Benjamin Cardozo, Felix Frankfurter, Arthur Goldberg, Abe Fortas, Ruth Bader Ginsburg, Stephen Breyer, and Elena Kagan. And of those 8, 7 were appointed by Democratic presidents. And we would consider all of these justices liberal under today's standards. Currently, of the Jewish justices Breyer and Kagan are currently sitting on the bench. So I'm not going to talk about all of them in detail. That would leave us here all night. But I thought it was worth talking about Louis Brandeis because he was the first Jewish justice. He grew up in Kentucky as the son of Jewish immigrants from Prague. He graduated from Harvard Law School at age 20 with the highest scholastic average in that law school's history, quite impressive. As a lawyer, he was known as the people's attorney for his activity in the great social and economic reform movements of the day, including workers' rights. He was appointed to the Supreme Court by President Wilson in 1916. And the Senate hearings were quite contentious. They lasted for 4 months, and much of the opposition was anti-Semitic, including from the Harvard president at that time, A. Lawrence Lowell, who later pushed for quotas on Jewish students at Harvard. Justice Brandeis served on the court for 23 years. Some of his notable achievements as a justice was creating the theoretical foundations for the right to privacy. He supported women's suffrage before the 19th Amendment was enacted. He was quite critical of the power of big business, and he was a strong advocate for free speech as foundational to democracy. Also of note, he was a leader in the American Zionist movement, and he persuaded President Wilson and the British government to recognize a Jewish homeland in Palestine. So our run of Jewish justices continued from Justice Brandeis until Justice Fortas resigned in 1969. And there was no Jewish justice between 1969 and 1993 when President Clinton appointed Ruth Bader Ginsburg. So I also want to talk briefly about Justice Breyer because he is currently on the court. He's 82 years old. He's been on the court since 1994. He also has a dazzling resume and background. He attended Stanford. He was a Marshall Scholar at Oxford. He went to Harvard Law School. And after graduating law school, he clerked as a law clerk for Justice Goldberg, one of our other Jewish justices. Among his jobs, Justice Breyer worked as a professor. He was an assistant special prosecutor in the Watergate investigation. He worked for the Senate Judiciary Committee. President Carter appointed him to the US Court of Appeals in 1980. And President Clinton appointed him to our highest court in 1994. He has a reputation as a moderate, and he's really known for his pragmatism. So now let's turn to our women justices. This is a beautiful portrait that you can visit yourself at the National Portrait Gallery when that reopens. The women justices are Justices O'Connor, Sotomayor, Ginsburg, Kagan, and our newest justice, Amy Coney Barrett. And of the 5 women justices, 2 were Jewish. I'm sure you're all familiar that Sandra Day O'Connor was our first woman justice. She was appointed by President Reagan in 1981 with unanimous Senate approval. It's hard to imagine unanimous Senate anything these days, but it was a different era in 1981. She grew up on a ranch in Arizona, attended Stanford Law School, where she graduated 3rd in her class. Graduating 3rd in her class from Stanford, she could not get a job. A major law firm interviewed her and offered her a job as a legal secretary. So her first job was actually working without pay for the county attorney of California's San Mateo region, just as a way to get her foot in the door. Obviously, she goes on to have a sterling career. She was the first woman in Arizona to serve as a Senate majority leader. And then she became a trial judge and an appeals judge in Arizona. And after being appointed by President Reagan, she sat on the court for 25 years and she retired in 2006. She was a pivotal vote in many, many cases, a real moderating force on the court. She is unfortunately suffering from Alzheimer's disease and she has retreated from public life. Justice Sonia Sotomayor is currently on the court. She's a native of the Bronx, and she's our first Latina Supreme Court justice, and she has served on the court since 2009. She's the daughter of immigrants from Puerto Rico. She graduated summa cum laude from Princeton, then she attended law school at Yale, and after graduating, she worked as an assistant district attorney and in private practice in New York. She was first appointed as a federal judge at the trial court level by President George H.W. Bush, a Republican. And then it was President Barack Obama who nominated her to the Supreme Court when Justice David Souter retired. She wrote an absolutely fantastic memoir called My Beloved World. If you haven't read it, it would be a beautiful book to read over the holidays. It's quite an inspiring, life-affirming story. Okay, let's talk about Elena Kagan, currently sitting on the court. She was born in New York in 1960. She was the daughter of an elementary school teacher and a housing attorney. And also of note, she pushed successfully to become the first Orthodox bat mitzvah at the Lincoln Square Synagogue in New York. So already quite an advocate at a very young age. She attended Princeton, has a master's in philosophy from Oxford, went to Harvard Law School. She served as a law clerk to Justice Marshall, an absolute icon. She has private practice experience. She was a law professor. She served in very high-level policy positions in the Clinton administration. She was the first female dean at Harvard Law School, where she served for 5 years. And it was President Obama who appointed her to be the first female Solicitor General. And the Solicitor General is the lawyer who argues cases for the government in front of the Supreme Court. And she only was in that role for 1 year before Obama appointed her to the Supreme Court to replace Justice Stevens. She was confirmed 63-37 with the support of 5 Republicans. And what I'm going to do is show you a humorous moment from her confirmation hearings. Senator Lindsey Graham was asking her some sort of convoluted question about the Christmas Day underwear bomber, and they had this colloquy that I am going to show you.
No, I just asked you where you were at on Christmas.
You know, like all Jews, I was probably at a Chinese restaurant.
Great answer. Great answer.
You know, I can
So
almost,
she is very quick and sharp-witted, to say the least. She's the only sitting judge right now who did not have prior judicial experience before ascending to the bench. And she's really known as a bridge builder who seeks common ground with the more conservative members of the court. Okay, so last but definitely, but definitely not least, Justice Ginsburg. There have been so many tributes to her as of lately with her passing on Erev Rosh Hashanah that I think you all are quite familiar with her, but I'll just touch on a few highlights here. She's a Brooklyn-born woman, graduated first in her class from Cornell. She was the first woman on the Harvard Law Review, where in law school she was one of 9 women alongside 500 men. And that was before she transferred to Columbia Law School, where again, she made law review and graduated first in her class. I think most of you know she was a dynamo of a litigator for the ACLU, where she took on sex discrimination cases. She created the Women's Rights Project at the ACLU, and she brought and argued the key cases that led the Supreme Court to affirm protections against gender discrimination. She was the only Supreme Court justice with a mezuzah affixed to her office door. And she had a poster on the wall with words that should sound very familiar to you. Zedek, Zedek, Tirdof. These are the beautiful words that Harriet mentioned at the start of your meeting tonight. Justice, justice, shall you pursue? She would sometimes say, what's the difference between a bookkeeper in New York's garment district and a Supreme Court justice? Just one generation. So what I want to do is show you now some brief remarks she gave about the importance to her of her Jewish identity. And I think this is a nice way to pay tribute to her.
Judge, born, raised, and proud of being a Jew. The demand for justice, for peace, for enlightenment runs through the entirety of the Jewish history, and Jewish tradition. I hope that in all the years I have the good fortune to continue serving on the bench of the Supreme Court of the United States, I will have the strength and courage to remain steadfast in service of that demand.
All right. Beautiful words from a real icon.
Judge,
Now shifting gears a bit to our newest justice, Amy Coney Barrett. She's 48 years old. She's the youngest member of the court. She graduated first in her class from Notre Dame Law School. After graduation, she served as a law clerk for Justice Scalia, and she very much shares his originalist philosophy in interpreting the Constitution. She only practiced law for 2 years. She never tried a case and she never argued an appeal. Most of her career was spent as a professor at Notre Dame Law School. Since 2017, she had been serving on the Seventh Circuit Court of Appeals. She is the 7th member of the current court to be raised as a Catholic, and she is the 6th conservative Christian member of the court, now facing off against a liberal wing that has been reduced to 1 Catholic justice, that's Justice Sotomayor, and 2 Jewish but secularist justices. So her appointment is dramatically going to shift the court in a conservative direction. It requires 4 justices to agree to take a case, to hear it on appeal at the Supreme Court level. And now, because the conservative wing of the court is more certain of the outcome of cases, they're more likely now to take up a range of quite divisive issues involving gun rights, conflicts between gay rights and religious rights, all sorts of new abortion restrictions. Most commentators would agree that this is the most conservative court now since the 1930s. And just not surprisingly here, justices who join the Supreme Court earlier in life usually serve for decades. And of course, that was some of the thinking about the appointment of Justice Barrett. The Supreme Court in recent years has been looked at favorably by the public. They are a branch of government that tends to have much more goodwill in general than the legislative or the executive branches. But of course, certain hot button issues and issues that are deemed too politicized can shape how people feel about the Supreme Court. And of course, it's not just a story of the Supreme Court that we should keep an eye on. It's also important to think about the federal judges at the lower levels in our judicial system. So our federal trial court judges and our federal appellate judges. And as we sit here today, President Trump has appointed nearly a quarter of all active federal judges. And his appointments have reduced the diversity of the federal bench. And so this slide shows you how different presidents have enhanced diversity of the bench with people of color, with women judges, and that we have Donald Trump is the only president in 40 years to actually make the federal judiciary less diverse. All right, so I want to talk to you about some of the most recent Supreme Court opinions that I think would be of interest to this group, interested in gender issues and justice issues and the rights of religious minorities. These are all cases in which Ruth Bader Ginsburg participated. And so many of them would have a different outcome if they were decided today. Okay, so case that was recently heard here was Little Sisters of the Poor versus Pennsylvania. And in this, a majority of the court endorsed the Trump administration's plan to give employers broad religious exemptions from the federal mandate in the Affordable Care Act that health insurance cover birth control. Okay. This was a 7-2 decision with Justices Ginsburg and Sotomayor dissenting. This decision came down in July. Justice Ginsburg noted in her dissent that the court's decision would immediately cause between 70,000 and 126,000 women to lose access to no-cost contraceptive services when their employers, for religious reasons, decide that they do not want to cover contraception. And without insurance coverage, the cost of contraceptives can put a big, sometimes prohibitive burden on women and people of all gender identities who utilize contraceptives. And so these exemptions that are now permissible are likely to have a particularly harsh effect on Black women, other people of color, and to exacerbate existing health and economic disparities in our country. And we can definitely expect more of these sorts of cases in the coming years in which religious entities claim that their religious beliefs trump other norms, beliefs, values, legislation, and the like. And here's another example, okay? Decision from June, Espinoza versus the Montana Department of Revenue. Here, the court narrowed the separation of church and state, and it did so by endorsing Montana tax credits that helped pay for students to attend religious schools. So again, separation of church and state, we can expect that gap to continue to narrow with the 6-3 balance of the court. A happier outcome was in Department of Homeland Security versus Regents of the University of California. All these decisions are from this summer. You may be aware that in 2017, President Trump moved to rescind the DACA program, which stands for Deferred Action for Childhood Arrivals, which had been created in 2012 by President Obama to protect dreamer immigrants from deportation. And Trump's attempt to shut that down was ruled unlawful. And so the DACA program is in effect, but we should note that today the decision, which had been a 5-4 decision, would likely tilt 5-4 the other way. I think we can expect a lot more activity around the issue of the Dreamers with a new administration and new policies. And so those policies are likely to be challenged, really from an anti-immigration perspective. Another case of interest is Bostock versus Clayton County, Georgia. And in this case, in a 6-3 decision, the court held that Title VII, which is the law that bans sex discrimination, forbids workplace discrimination against gay and transgender employees. Okay, so this is Mr. Bostock, who was the initial plaintiff in the case. He worked for Clayton County as a child welfare services coordinator, got very positive performance reviews until 2013. He begins playing in a gay recreational softball league. All of a sudden at work, he's getting criticized for participating in the league, negative comments about his sexual orientation. And lo and behold, around the same time, the county tells him they're going to conduct an internal audit of the program funds that he managed. And shortly thereafter, he is terminated for conduct unbecoming of employees. And what's interesting in this case is that it was written by Justice Gorsuch, who is considered a conservative justice, but he you looked directly at the statutory language of Title VII, did a plain reading of the statute, said the legislative history doesn't matter. What legislators thought in the 1960s when the law was enacted doesn't matter. All that matters is the language. And under the language, it is illegal to discriminate in the workplace against people on the basis of their sexual orientation. All right, so now let's talk about reproductive justice, because this is where we can expect a lot of major changes in the years to come. There was a decision this summer in the case of June Medical Services versus G. And in that case, the Supreme Court, in a 5-4 decision, and I mentioned 5-4 because you have to imagine now that that would flip the other way, did uphold abortion rights. This was a major ruling. It struck down a Louisiana law that had placed restrictions on doctors who perform abortions. You can see here, this slide sort of shows the precedent that led up the cases that preceded the June Medical Services case. And the governing standard is that states can enact laws that restrict abortion as long as they don't present an undue burden to accessing abortion care. And the Louisiana law at issue in this case was deemed an undue burden. What that law did was it required doctors who performed abortions to have admitting privileges at a hospital within 30 miles. These sorts of laws are called TRAP laws, targeted restrictions on abortion providers. They are purposefully designed to impose unnecessary regulations on clinics and doctors who provide abortion care in order to curtail or even cease their ability to operate. And there's a wide array, some of which are listed on this slide. They include laws that require various waiting periods, that mandate ultrasounds, that mandate certain forms of counseling with biased information, that require parental involvement when minors are seeking abortions, and so on and so forth. And in the last decade, 33 states have enacted 479 abortion restrictions. And Louisiana is a state with many, many of these laws, and these laws do fulfill their intended purpose. There's only one clinic that provides abortion in the entire state of Louisiana to serve 1 million women of reproductive age in that state. And Louisiana is not alone. There are 27 cities in the US that are considered abortion deserts, cities where women have to travel 100 miles or more to reach an abortion provider. 89% of counties in the US have no clinics that offer abortion care. So for many women in this country, the right established in Roe versus Wade does not exist in reality, right? It's really a right without a remedy. And we know that women who are denied an abortion face greater likelihood of living in poverty, of staying in abusive relationships, and experiencing mental health issues. And so this chart talks, highlights states that were enacting restrictions versus some states that were moving in the other direction to protect or expand abortion access, but they're in the minority as compared to states that are restricting abortion. That's just from 2019. And this map helps one identify a state's hostility to abortion rights. And you can see Maryland there is considered supportive of abortion rights. We are in that teal blue color, but you can see, especially across the South, the deep South, and in the Midwest, states that are very hostile to abortion rights. And we can expect that Justice Barrett will uphold TRAP laws, if not be in a majority that overturns Roe versus Wade. Her brief time on the Seventh Circuit, she issued some decisions that looked kindly on TRAP laws. And she's made her position against abortion clear. I mean, it's not a secret, it's not a mystery. She signed an anti-abortion ad in 2006 calling for an end to Roe versus Wade, and she's called Roe versus Wade a, quote, barbaric decision. In 1998, she wrote that abortion is, quote, always immoral. So, having Ruth Bader Ginsburg's seat, now filled with Justice Barrett, shifts the balance in an anti-reproductive justice direction. Definitely. This, despite the fact that polling consistently shows that 77% of Americans support upholding Roe versus Wade. Okay, there are two recent cases of note that were just argued, and we're waiting for those decisions. So these cases will be amongst our first glimpse of the newly constituted court. So the first one is California versus Texas. As it says here, the Affordable Care Act litigation saga continues. So yes, we're still litigating the legality of the Affordable Care Act. In 2012, Justice Roberts sided with the 4 liberal justices on the court to save Obamacare from a challenge to the individual mandate by ruling that it was a tax and it was constitutional. In 2017, Congress amended the ACA to lower the individual mandate to 0. And yet in this legal challenge, there are 20 states claiming that because the individual mandate no longer generates any revenue, we can't call it a tax anymore, and so it's unconstitutional on those grounds. And so the Supreme Court heard arguments earlier this month on whether the individual mandate must go, and if so, whether the rest of the Affordable Care Act falls along with it. 20 million people currently have health care due to this law. This is a very high stakes decision. But based on the oral argument, those who are reading the tea leaves strongly got the sense that while there may be 5 votes to strike the individual mandate, the rest of the Affordable Care Act will be severed and will survive, effectively leaving in place our current status quo. So that argument was watched very, very closely, and it's based on the questioning of the justices, where you can kind of see which way that they are leaning. Okay, the other case that I'll talk briefly about is Fulton versus City of Philadelphia. And the issue in this case is whether the City of Philadelphia violated religious liberty rights when it cut ties with Catholic Social Services, a foster care agency that refuses to place children with same-sex couples. So here, Catholic Social Services is saying, based on our religious beliefs, we can't place foster children with gay parents. And you have the city that funds foster care saying that level of discrimination is not okay with us. We will no longer use you as a provider. So it's, again, one of these cases where religious beliefs and public policies are coming to a head. And, you know, the prediction here is that Catholic Social Services is likely to prevail. Okay, and so the last issue I'll talk about, and of course, happy to take questions, is the ERA. And here's the language of the Equal Rights Amendment. Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. The Congress shall have the power to enforce by appropriate legislation the provisions of this article. Sounds fantastic, but it's not the law. It's not in the Constitution. It was initially authored in 1923, not long after women got the right to vote. Congress proposed it in 1972 and very quickly passed it by the constitutionally required 2/3 majority. However, amendments to the Constitution can only take effect when 3/4 of the states ratify them, meaning you need 38 states to ratify a constitutional amendment. So within a year of its introduction, so by 1973, 30 of the needed 38 states had passed it. But conservative activists stopped the momentum with scenarios of gender neutral bathrooms, same-sex marriage, and women in the military. Oh, the horrors, all things we live with today with no problems in society. We have all those things, and it turns out things aren't that bad, but it was very effective. And some of you may have watched the series Mrs. America, which is out and available on Hulu, which traces the battles between Phyllis Schlafly on the conservative wing fighting against the ERA and fighting against Gloria Steinem and Shirley Chisholm and other feminist activists of that era. Okay, so things were really stalled for several decades after we hit that 30 vote threshold. And in 2017, feminist activists renewed their push to pass the ERA. And in January of 2020, pre-pandemic, Virginia was the 38th state to ratify the ERA since Congress proposed it, technically pushing the ERA across the threshold. But there are still some hurdles in the ERA's path, okay? So the ratification deadlines that Congress initially set after it approved the amendment have lapsed. So there's an issue whether these later ratifications count. During this time period, 5 states that initially approved the ERA rescinded their approval. Does that matter as a legal question? And as it stands right now, the head of the National Archives has refused to add
How are you?
the ERA to the Constitution.
I'm listening to a Zoom.
All right, I hear
now.
another voice there. If you could mute yourself.
What?
I don't know who it is. There's someone talking.
Whoever's on the phone, please mute yourself now.
You don't
Thank
want to
you.
eavesdrop on your conversation. Okay, so there are 2 lawsuits right now seeking to have the head of the National Archives add this to the Constitution. One lawsuit is by a coalition of women's advocacy groups, and one is by a coalition of state attorneys general, including the AG of Virginia, Mark Herring. So we have to stay tuned on what's going to happen with this. Here is a clip of the House of Representatives. They did pass a vote to extend the deadline. Again, there are legal questions whether that would be effective, and the Senate hasn't similarly voted. But here are some words by Representative Jackie Speier that really give us a sense of what is at stake here.
It's about sisterhood, motherhood, survival, dignity, and respect. The world recognizes this. Of the 193 countries in the United Nations, 165 have put this kind of language in their constitutions, but not the United States of America. From the Women's March to the Me Too movement to the Pink Wave, the outrage we've seen among women is because we have been disrespected, devalued, and diminished in our society. And we are fed up. It's no wonder recent votes to ratify the ERA came in 2017, 2018, and 2020, because we want the ERA now. We've waited for almost a century for the ERA. I want to thank my Republican co-sponsors.
All right, so then she goes on for some thank yous, and there's some other speakers there. I mean, the ERA, if passed, isn't going to single-handedly solve discrimination overnight by any means, but it would definitely provide a stronger legal tool to challenge discriminatory legislation and to uphold congressional attempts to rectify discrimination. So it could be a really, really powerful tool in moving towards gender justice. So in conclusion, I don't think we can count on the Supreme Court at the time to serve as a backstop against discrimination against women. And this is, you know, I makes me sad to have to come here and say this, given that we're also celebrating the 100th anniversary of the right to vote for women. But that is where we sit right now in the politics of the moment. Of course, there are things we can all do to advance gender justice in other ways, you know, electing more people to office who are committed to women's rights, supporting progressive legislation, progressive legislators, women's rights advocacy groups. We can support President-elect Biden in diversifying the bench and support the Senate campaigns in Georgia now so that the Senate will be able to appoint a diverse federal bench and new Supreme Court justices if any of our current justices retire. So there's still things we can do, but the Supreme Court is no longer the guarantor of justice the way it has been oftentimes in the past. And so with that, oops, it
It's
is
about
about sisterhood. I
sisterhood.
want to thank you all. You can see my email address here. Anyone is welcome to email me at the University of Baltimore anytime. And if you're on Twitter, you can follow me at Prof. M. Gilman, and I will turn off my slides.
Thank you, Professor Gilman. I have a couple of questions that come from the audience. The first one is, why did Justice Kagan vote for the right of companies to decide whether to pay for birth control?
Yeah, part of that case was really about administrative law and the power of a government agency to approve it. So her ruling is less about the substance of what was done and more about principles of administrative law and what agencies can and cannot do and whether the proper procedures were followed in that case.
Mm. The second question is, on what legal basis does Judge Barrett base her opinions? How does her originalist background support her views?
Okay, so with that perspective, she's really looking at what did the framers of the Constitution think in the 1700s when they wrote the Constitution, okay? That is a philosophy very well associated with Justice Scalia, and it's called originalists because they're looking for the original meaning. But, you know, it's not clear that our framers of the Constitution, that that's what they wanted. If you went back and talked to them, you probably would have heard that they want the Constitution to grow and develop along with the country because they were smart enough to know they couldn't foresee all the things that would happen to this nation. And that's really the problem with the originalists, is it's ascribing a meaning and an intent that probably isn't there, that the historical record does not support. But it's a very textual approach, just looking at the meaning of words and what they meant in the 1700s. And so it's really ill fit to handle the complex dynamics of modern society.
Right. Okay, what is your feeling about Supreme Court justices having limits of term and extending the number of court justices?
Well, I think more highly of it now. That is definitely an idea that's gaining a lot of traction and floating around, but definitely more on the progressive side. Definitely with term limits, many other benches, you know, among state courts and state highest courts do have term limits, and in other countries, highest courts have term limits. So it's, you know, not something we're familiar with our Supreme Court, but it's common in many, many courts and with many, many judges. And it would ensure a more, it would have the potential to ensure a more robust and diverse set of viewpoints. And we wouldn't be in this position of, you know, justices retiring or very sadly passing away with that, you know, and leaving everything a political struggle rather than sort of a planned rotation. Extending the number of court judges, which you'll sometimes hear as calling court packing, is, I actually haven't thought a lot about it. I'm worried right now that all my instincts are just like, yes, so that we can get fairness and decency on the court. But the Constitution doesn't require 9. That's not like a magic number that's in the Constitution. It's really by convention, the Supreme Court, and by law now, but a law that could easily be changed. Over the years, the Supreme Court has been different sizes. It's been smaller, it's been bigger. So that is just a matter of a congressional enactment. It's not a constitutional requirement. And that's why the idea is being floated, because it's possible. But would it be possible with a Republican Senate? Absolutely not. That idea will, if the 2 Democrats don't win in Georgia, you can forget even talking about it, because you would need the House and the Senate to make that decision.
This next question is a statement and then a question. It seems that there are many women in this country who are very anti-abortion and will only support candidates that support this one issue. Do you know what percentage of women support ERA and are pro-life?
Yeah, I don't know the exact percentages on that. I know 77% of Americans support Roe versus Wade, and public polling all the time consistently shows vast majority supporting Roe versus Wade and vast majority supporting contraception. I mean, it's amazing. It's the year 2020 and we're fighting over access to contraception. Like, wasn't this resolved, you know, in the Griswold decision? It was like in the 1950s. So that's pretty mind blowing. And also the vast majority of the public also supports the ERA. In fact, most people think it already exists. They've heard about it and they think it was already adopted into the Constitution. And when you tell them, no, no, it was never adopted, a lot of people are surprised. They don't realize that. So these are issues with a lot of popular political support, but the highest court right now doesn't reflect the beliefs of the majority of the populace. That's one reason I showed you all the slide on sort of the popularity, the faith in the Supreme Court, because as the Supreme Court gets more and more out of step with the average American, we might see those numbers really slide. And it's important for the court to have the respect of the people, because it doesn't have power to enforce its own laws, right? It hinges on the other branches to enforce its laws and the support of the American people to give its decisions, you know, stature and credibility. So it's something people, scholars really keep an eye on, is how aligned the court is with popular opinion.
Okay.
Ooh, how many states have an ERA? You know, I knew that at one point. I don't have that at my fingertips. I see that as a question. But there are several states that have an ERA as a matter of their state constitution. And you know what? The sky has not fallen. So I had an opportunity to debate this issue on the radio show 1A on NPR when it was hosted by Joshua Johnson. And I was there just as the professor, unbiased, to just talk about dynamics of the ERA. And on the opponent side was Phyllis Schlafly's daughter, who's now taken up this mantle. And one of the points that I raised was, look at all these states that have an ERA, and this like parade of horribles that you talk about just hasn't happened. It's worked well in those states and has not been a disruptive force. Yes, and Maryland is one of the states with its own ERA. So I think for social justice lawyers like myself, we, depending on the state we live in, we'll be turning more to the state courts for achieving justice than federal court. But it's really a patchwork across the country. We have red states, we have blue states. So we've already seen a lot of blue states, Maryland, New York, California, and others, really turning to their state attorney generals and their state courts to advance justice, because the federal courts are just not a welcoming forum right now. So we can expect to see in progressive states a shift to state courts to advance justice objectives.
Okay, I think that's it. All the questions. Okay.
They're great questions.
Yeah, I want to thank you so very much. You took an incredible amount of information and condensed it so concisely, and we certainly appreciate it. I would like to, yes, think about having you to come back, because in 6 to 8 months, let's see where we are with some of the stuff that's beginning to happen.
Yeah, it's an interesting time. Who knew, like when I came here in November, we would really be at this pivotal precipice time, right? With one chapter closing and a new chapter opening. Like, wow, this is that junction. This is that pivot point. And you're right, you know, a year from now, we'll know more, we'll see more, and activists will be strategizing about how do we grapple with the new reality.
Right.
Yeah, yeah.
Thank you so very much. I think our president wanted to say some words. Marcia?
Thank you. I want to thank Michele for talking to us about the Supreme Court and what we should be expecting in the coming years. What you said was timely and very informative, and we're so happy we came up with this idea when we did, and look where we are now. Yeah, I also want to give special thanks to our Federation's Vice Presidents, CeCe Rund, Karen Engerman, and Julie Bernstein, Treasurer Ann Fishkin, and past President Eve Oglestein. Thanks for all your assistance and support for this meeting tonight. You are the best. Thanks to everyone for joining us this evening. Please consider becoming a friend of Federation, which, excuse me for 1 second.
We have an extra participant.
Bark. Just when I'm talking, okay. Please consider becoming a friend of Federation, which helps us fund the programs we planned for you. We emailed you the Friends and the server forms when you received the link. So you can find these forms, or you can find these forms on our website. Do not forget our social action project this month, which will support Hannah, and mark your calendars for January 21st for our winter meeting. Be safe, take care, and happy Thanksgiving to all. And now you can unmute and socialize a little bit. You can also ask more questions if Michele wants to stay around.
That was great.
Happy to hang out.
Yeah.
Yes, I think it was wonderful. Thank you, thank you.
What can we do? What can we do to be sure we get the Democrats in Georgia, the two, besides money? Is there anything else?
Yeah, make phone calls.
Make calls and write letters, I would assume.
Yeah.
Yeah. But I'm also hearing some caution about outsiders not interfering too much because it can have a backlash effect. That's what they think may have happened in Maine, is that all the outside money pours in and local residents, you know, resent that. And so it's probably a delicate balance.
Mm-hmm.
Okay.
Okay, is there anything else?
I just had the question. I was wondering about Justice Robert, and I've heard it said. Wait, I've heard it said that he had he's worried about the legacy of the Supreme Court. And I was wondering how you thought that might play out.
Yeah. So the question, it was a little hard to hear. Linda, we're getting feedback on you. Thank you. Justice Roberts is the Chief Justice now. He is concerned about the legacy of the Supreme Court and that it having the faith of the people. But it's ironically, he is now sort of a moderate on the court, but really he's not in terms of his substantive legal leanings. It's just that the court has drifted so far to the right. And so I imagine he's going to be in a very difficult position of trying to broker all sorts of less extreme outcomes. But many of you may be aware that Justice Alito recently spoke at a Federalist Society event. This was last week, where he really went on a tirade and really conduct unnumbing of a Supreme Court justice, but also substantively what he said is really, really of concern. He talked a lot about oppression of conservatives and oppression of religious minorities, and made very, very clear where at least he and probably some of the other justices are going to come out on issues. And so that's, I just think Justice Roberts, for all his like political skills, might be very hard strain to control.
Well, it's just the other thing he said this week, I think, with the ACA Act, was that why did Congress make changes? I think that was the reason why they sort of the legal, if I understood correctly, you know, that was. So do you think there'll be more things where they say, well, you guys need to fix this legislatively, don't make us make the law?
Yeah, that's a good question. The thing that's frustrating is there are many times where court says, we're not going to make a decision here. That's for the legislatures to do, right? And yet when the legislator does something progressive, the conservative justices are quick to find it unconstitutional. So like you either believe in like the legitimacy of political branches to express the will of the people or you don't. And so with the Affordable Care Act, Congress did go back and reduce the individual mandate, which was the problematic part, to 0. And so they were trying to assuage those concerns. But for the states who are opposed to it, there's just, because it's so associated with President Obama, there's literally nothing you can do to appease them. They'll come up with another theory, no matter what ours does or enacts.
Any other questions or comments? We want to thank you again.
Thank you. It was great.
Thank you.
Thanks so much.
Thanks.
Excellent presentation.
Great to see all this energy and engagement late on a Thursday night. I'm so impressed with the
You were
wonderful
saving
women
up
of Maryland. Exciting.
Well,
Thank you, Michelle. We look
Bye-bye.
forward to hearing from you again.
Thank you.
Anytime.
Thanks
Bye.
again.
And thank
Thank you.
everyone that came. We enjoyed being with you, everyone. Even my dog who decided to bark just when I was speaking.
Yay, Layla.
Yeah, Layla. Yeah, that's right. That's for sure. Okay, we look forward to seeing everybody and continue to work together. You know,